short, by a notification bearing number such and such dated December 16, 2016, had announced the state level selection test for recruitment of assistant teachers in physical education and work education in recognized non-government aided sponsored schools in West Bengal, hereinafter referred to as the first SLST 2016 in short. The petitioners of this batch of writ petitions had participated in the said selection test but were unsuccessful. The petitioners are challenging the said selection process on the grounds that it is vitiated by corruption and malpractices of the respondent authorities. They are also challenging the legality and validity of the order of the School Education Department, Secondary Branch, Government of West Bengal, bearing number such and such dated May 19, 2022, so far as it relates to creation of 1600 supernumerary posts of assistant teachers with breakup of 750 posts of work education and 850 posts of physical education teachers. To appoint all waitlisted candidates of the said first SLST 2016 under the said two categories, and the notices bearing number such and such dated October 14, 2022, whereby the Commission had notified the dates of counseling for filling up the said supernumerary post. In order to afford opportunity of being heard, the said waitlisted candidates were notified. Some of them had applied for their addition in one of the writ petitions, being WPA 25056 of 2022, except one, being CAN 11 of 2025, which was not moved. All applications were allowed. In consequence, the applicants of those applications have been added as respondent number 7 to 301 in the said writ petition. The legality and propriety of first SLST 2016 and the said two notifications are under challenge in the writ petition. The added respondents, in terms of the said notification dated May 19, 2022, have already recommended for appointment long back, but could not be appointed due to the interim order of stay passed in one of the writ petitions. Therefore, there is an imminent urgency in deciding the challenge to the said notification dated May 19, 2022 and October 14, 2022. As such, the said challenge is taken up for consideration independently first, keeping the other dispute issues raised in the writ petition pending. The state and the added respondent at the threshold have raised an objection as to the locus standi of the petitioners to maintain the writ petitions, particularly to throw challenge to the said notification dated May 19, 2022 and October 14, 2022, as the petitioners are unsuccessful candidates of first SLST 2016. Therefore, the first issue falls for consideration in the matter is thus whether the petitioners, being unsuccessful candidates of relevant selection tests, are entitled to challenge the notification dated May 19, 2022, and whether such challenge is barred by limitation. The issue being related to maintainability of the writ petitions, the respondent have the right to begin. The argument of the learned counsel for the parties to on the said issue are recorded herein below in seriatim. Now the argument of is starting from this respondent's argument, Mr. Sengupta onwards. I have recorded the submissions of all parties. Then Mr. Vikas Ranjan Bhattacharya, petitioner. The next issue, the second issue, calls for consideration is as follows. Whether the creation of supernumerary posts to give appointment to the waitlisted candidates of the panel of first SLST 2016 in the post of assistant teacher for the subject work education and physical education in upper primary level of school is legally sustainable. Then again, according to the argument of the learned counsel for the parties, on the second issue are recorded herein below in order of their appearance. Now, the court on first issue. The Honorable Supreme Court in the case of Dharanidhar Mishra Supra, cited on behalf of the petitioners, has observed that in a case where the demand for justice is so compelling, a constitutional court would exercise its jurisdiction with a view to promote justice and not to defeat it. Keeping the said object in view, the issue of maintainability is addressed. The decision of learned single judge of this court in the case of Ganesh Chandra Mukherjee, cited on behalf of the respondent, is completely irrelevant to decide the issue, inasmuch as in the said decision objection was taken as to the jurisdiction of the court to maintain an application uh, under Article 226 of the Constitution of India Constitution against a company, which such is not a challenge here. I am at one with Mr. Bhattacharya that to decide the issue of maintainability of writ petitions raised by the respondents, the averments made in the writ petition must be taken to be true and correct. If that if the said test is applied, the issue of maintainability vis-a-vis the local standard of the petitioner cannot be decided at the threshold as a preliminary issue. The Honorable Division Bench in MAT 723 of 2025, while affirming the order of injunction passed by this court, had never directed the said issue is required to be heard first, deferring the decision on merit. Therefore, I am unable to convince myself to accept the argument of Mr. Sengupta that the issue of maintainability should be decided as a preliminary issue, particularly when the said issue raises a mixed question of law and fact. To answer the issue under consideration, it is necessary to understand the scope of present writ petitions. The petitioners are challenging the legality and validity of the entire first SLST 2016 so far as it relates to the recruitment of assistant teachers at the upper primary level of recognized non-government aided sponsored schools in West Bengal for the subject physical education and work education on the grounds that the said selection test is initiated by malpractices, illegal actions, and manipulation of the respondent authorities. The petitioners, though, have participated in the said selection test but were unsuccessful. As such, their locus to maintain this said challenge is questioned. There, there was another recruitment drive conducted by the Commission in the year 2016 for recruitment of assistant teachers for class 9, 10, 11, 12, Group C, Group D post. In several writ petitions, the said selection test was challenged on the self-same grounds of fraud, illegality, and malpractices of the authorities. The challenge was sustained. As a consequence, the entire selection process was set aside by the Honorable Division Bench of this court in the case of Boishaki Bhattacharya. The said decision was affirmed by the Honorable Supreme Court. In the backdrop of such facts and circumstances, it will not be just and proper to dismiss the writ petition at the threshold on the ground of maintainability without verifying the veracity of the allegations made therein. The petitioners are alleging the fresh vacancies have been created in the name of supernumerary courts. As such, all participants in the said relevant selection test have a right to be considered against those vacancies. The allegation needs to be investigated on merit, and without such step being taken, the writ petitions cannot be dismissed on the ground that the petitions, being unsuccessful in the relevant selection test, have no locus standi to maintain the writ petitions. The Honorable Division Bench of this court in the case of Boishaki Bhattacharya Chatterjee, while overruling the similar objection, had observed at paragraph 163 that writ petitioners are participants of the selection process, albeit unsuccessful by most, but they are entitled to fair consideration in the selection process. The said paragraph is quoted below for ready reference. Then 163 quoted. The Honorable Supreme Court in Vidya Devi versus State of Himachal and others reported in 2022 Supreme Court cases 569 has held that delay and laches cannot be raised in a case of continuing cause of action or where the facts shock the judicial conscience of the court. Moreover, there is no period of limitation for courts to exercise constitutional jurisdiction to do substantial justice. The action complained of shocks the judicial conscience of this court, inasmuch as the state, by the impugned notification, has sought to inject life into a dead panel. Such action of the state is not legally sustainable. The present context demands consideration of paragraph 147 of the decision of the Honorable Division Bench in the case of Vaishakhi Bhattacharya. 147 quoted, no appointment can be made after expiry of the panel, as the panel is not a perennial reservoir for appointments. Panel is valid for the declared vacancy and for the specific period. Appointment towards future vacancies cannot be made from the panel. Appointments made in violation of Article 14 and 16 of the Constitution of India are a nullity. Courts have no jurisdiction to direct appointment to be made beyond the validity period of panel. Therefore, in the facts and circumstances of the present case, the alleged delay and laches are no fetter to maintain the present challenges. The decision cited on behalf of the respondent in the case of Aflatun and others versus Chennai Metropolitan Corporation in Murugeshwan are therefore factually distinguishable. The petitioners had participated in the relevant selection test, though unsuccessful, but they cannot be said to be totally strangers to the said selection process. In view of the nature of allegation and relief claimed in the petitions, the petitioners cannot be thrown overboard on the allegation of not having locus standi without addressing the said allegation on merit. In view thereof, the proposition of law laid down in the following decision on the point of locus standi to maintain the petition cited on by the respondents in the case of Ayub Khan, Tridevi, Himanshu, Gyan Shabai, Tajveer Singh, etc., are not applicable in the present case, inasmuch as in all those decisions, the Honorable Supreme Court had decided the said issue upon consideration of the cases on merit. In case of Bombay Dyeing, Supra, and in case of Taibai, the issue was relating to the grant of an order of injunction and the maintainability of the lease, which is not the issue under consideration. Therefore, the said decisions are not relevant to the context. In the case of Chandrakanto Ganguly, the Honorable Division Bench of this court has held that when executive action of the state is challenged, the court must tread with caution and should not overstep its limit, but with the further observation that the court is warranted only when there is oblique motives and miscarriage of justice. Petitioners have alleged both. It has already been held that the step taken by the state to give life to an expired panel prima facie is not legally justifiable. Therefore, the said decision cited on behalf of the respondent is of no help to them. It is not the validity of the decision, but the validity of the decision-making process to create supernumerary post is under challenge. Therefore, the said challenge is open to judicial review. The premise of the challenge being different on the decision of the Honorable Division Bench of Delhi High Court in the case of S.S. Goel is not applicable in the present case. In view of the above discussion, the first issue was answered affirmative. The petitioners have locus standi to maintain the writ petitions and are entitled to challenge the notification dated May 19, 2022 and October 14, 2022. The court on the second issue. The Government of West Bengal Education Department Secondary Branch by a notification dated September 20, 2016 had framed the rules regulating the manner and scope of selection of person for appointment to the post of teachers for upper primary level of schools, namely the West Bengal School Service Commission, selection for appointment to the post of teachers for upper primary level of school, Rules 2016, hereinafter referred to as the said Rules of 2016 in short. The commission, being designated by the said rules of 2016, had notified first state level selection test, the first SLST 2016 in short, for recruitment of assistant teachers in physical education and work education in recognized non-government aided sponsored school in West Bengal, wide notification bearing number such and such dated December 16, 2016 against the vacancies available under the said rules of 2016. The relevant portion of the said recruitment notification dated December 16 is quoted below for ready reference. Emphasis has been supplied against vacancies available under the West Bengal School Service Commission selection for appointment to the post of teachers for upper primary level of school, Rules 2016. The said rules of 2016 prescribes a complete mechanism for selection of persons for appointment to post of teachers for upper primary level of schools. The Rule 8 thereof lays down the procedure as to how the vacancies for such recruitment process would be ascertained. The said rule prescribes that the district inspector of schools, on being asked by the director of school education, shall prepare a report regarding the number of vacancies in posts and shall send it to the director of school education. The said director, on receipt of such report with due approval from state government, shall send it to the central commission. Firstly, before the date of publication of advertisement, before inviting application. Lastly, 15 days from the date of publication of the result of the written examination or interview list, as the case may be. The relevant portion of Rule 8 of said Rules of 2016 is quoted below. Then Rule 8 is quoted. Rule 16 of the said Rules of 2016, apart from mandating that each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or the date of advertisement for the next recruitment process, whichever is earlier, by virtue of the proviso thereof, also stipulates that the names of candidates shall not be recommended against any post other than the post applied for or against any vacancy which has not been notified in terms of sub-rule 3 B of the Rule 8 of said Rules of 2016. Relevant portion of the Rule 16 of the said Rules of 2016 is quoted below. Clause 11 of the recruitment notification dated December 16, 2016 reiterates the said mandate of the said Rules of 2016. The same is also quoted below. The position of extant rule, as it appears from the above discussion, is that the recruitment drive was initiated to fill up the vacancies available under the said rules of 2016. The Rule 8.3 thereof fixes the time limit within which such vacancies are required to be ascertained and reported to the Commission, but the said procedures were not followed in creating the vacancies for the waitlisted candidates of first SLST 2016. The state has created the said vacancies in the name of supernumerary post with the approval of the committee. The petitioners in WPA 25056 of 2022, by way of supplementary affidavit, have brought the cabinet memorandum bearing number such and such dated May 5, 2022 on record. The Principal Secretary of the Government of West Bengal School Education Department, by the said memorandum, inter alia had proposed to create 1600 supernumerary posts with breakout of 750 and 850 for absorption of all waitlisted candidates of first SLST 2016. To understand how the said vacancies in the name of supernumerary posts were proposed to be created, the said Cabinet Memorandum dated May 5, 2022 demands a close look. The said memorandum records the proposal of the Central School Service Commission for creation of 5,261 posts. The relevant portion of the said